A very good afternoon to all of you friends. A very good afternoon to all of you. On behalf of BYJU'S Exam Prep, the most comprehensive preparation app for all exams, I, Shurojit Bhaduri, welcome each and every one of you for today's live session on previous year's question discussion. So a very warm and a hearty welcome to each and every one of you friends. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So today friends, we are going to discuss another two very important passages that came in CLAT 2021 examination. Since you guys are preparing for CLAT 2022 or CLAT 2023, it is absolutely important that you guys are aware of the kind of questions that did come in CLAT 2021. So friends, let us begin. But before I begin with today's session, here are certain very important announcements from BYJU'S Exam Prep. BYJU'S Exam Prep brings to you a crash course for CLAT 2022 examination. Enroll yourself if you are preparing for CLAT 2022 for this crash course for CLAT 2022. BYJU'S Exam Prep also brings to you a comprehensive preparation course along with foundation module for CLAT 2023. If you are one of them who are preparing for CLAT 2023, and you should be aware of the fact that CLAT 2023 is going to take place in December 2022 itself. So you do not have much time in your hand. So guys, enroll yourself for this fantastic course from BYJU'S Exam Prep for CLAT 2023 aspirants. This is the comprehensive preparation course along with foundation module. So guys, let us begin. Let us begin with today's session, friends. Let us begin, friends. Today, you have to read this passage 7. Okay? Read passage 7 very carefully. What do you understand by res judicata has been explained in this particular slide. So read this slide very carefully. Okay? Most of you say that they are done. Fantastic. Moving on to the next slide, guys. Okay? So you understand what does section 11 of the Code of Civil Procedure, or the principle of res judicata deals with. What that doctrine is, insofar as people having, if there is a litigation between two parties and a judgment has been given, they cannot again institute in another court the same question, so that there will be vexation so that the litigation continues. That cannot happen. Okay, are we done? The last 15 more seconds for you guys. Okay, okay, moving on to the third slide. The last 15 more seconds for you to read this slide, guys. Okay, moving on. Question number 1 is up there on your screen. In which of the following res judicata is applicable to? Is it applicable to civil suits, writ petitions, none of the above, both A and B? Res judicata is definitely applicable in civil suits. Is it also applicable in writ petition? Yes. So the correct answer is option D. It is applicable in both. Option D is the right answer. Is that clear to each and everyone? The principle or the doctrine of res judicata is applicable in both civil suits as well as in writ petitions. Question number 2. The doctrine of res judicata, as you have read in the slide, is applicable to writs if the decision is on merit, order is a speaking order, both A and B, neither A or B. Please tell me the correct answer. The correct answer is decision is on merit and the order is a speaking order. So both A and B are correct. So the correct answer becomes option C. Is that clear to each and everyone? So if you read the passage carefully, I am sure that it will not be difficult for you to answer the question. But for that, you need to understand the passage. That's the most important thing. That's the most significant thing. Question number 3. On which of the following is the doctrine of res judicata based? Option A. No one should be vexed twice for the same cause more than once. Okay, correct. It is in the interest of public that finality should be attached to the decision of the courts. Yes. There should be an end to litigation. Yes. So option D is the right answer. Is that clear? Is that clear to all of you? So are you understanding how to solve? Not difficult at all. So I would request each and every one of you, if you are liking today's session, do press the like button. Do subscribe to this channel. Do press the bell icon so that you do not miss on any notification for our beautiful videos. Question number 4 is up there on your screen again. Which of the following is correct? If a writ petition is filed under 226 of the Constitution and the same is rejected on merits by a speaking order, another petition under 32 of India is not maintainable. Absolutely. The doctrine of res judicata is founded on the principle that it is in the interest of public public at large, and that a finality should be attached to a binding decision of a court. Technical rule of res judicata only prevents multiple filing of petition under 226 between same parties. No. The correct answer is option D. Option D is the right answer. Is that clear to all of you? Question number 5. Did the High Court dismiss Mr. X's application on merits, or was it on a technical ground? It was on a technical ground that Mr. X could go to some other forum to get remedy. He took that remedy. Now, is the principle of res judicata applicable in such a situation? Of course, no. Res judicata is not applicable in this situation. The correct answer is B. Am I clear? Is that clear to each and every one of you? Is that clear to each and every one of you? Please. Okay? Fantastic. Before we move on to the next set of passage, BYJU'S Exam Prep brings to you an express course for Maharashtra CET, A-Lit, SLAT, B-Lit, Jamia LLB 2022. If you are preparing for Maharashtra CET, A-Lit, SLAT, B-Lit or Jamia for the year 2022, do get yourself enrolled for this express course. Moving on to passage number 8. The last 15 more seconds for you. The last 15 more seconds for you. A sacrament means some religious thing, okay, very holy thing. Sacrament or samskara. Okay, moving on to the next slide. Prima facie means on the face of it. Prima facie means on the face of it. Mr. Pandey. Is that clear to each and every one of you? Any doubts? Okay, moving on to question number 6. A and B are married. Here comes C. In front of the colleagues, Mr. A says that Mr. C is my wife. By saying, I might say that Miss X is my wife doesn't mean that Miss X is my wife, right? So the correct answer is, read the options and give me the right answer. Read the options and give me the right answer. Okay, the correct answer, absolutely. A is not liable at all because he has not solemnized any marriage with C. He just has said something. Question number 7. What do you mean by solemnization of marriage? What do we understand by solemnization of marriage? Okay, solemnization means celebrating the marriage with proper customary rites, ceremonies of either parties to the marriage. So option A is the right answer. Option A is the right answer. Is that clear? When there is a marriage, there are a lot of ceremonies, lot of customary rites that takes place. That is called solemnization of marriage. Question number 8. This is true. This is also true. If a husband solemnizes the second marriage during the substances of the first marriage, it is not an offense. However, if it is an offense if the wife commits the same act, it's also true. Not correct. Option B is not correct. It's false. Am I clear? Now D, now I'll tell you. There were certain questions relating to option D. Now, to my knowledge, also D can be the right answer, but CLAT has said that B is the right answer. If you say D, I will agree with you because this is also wrong, but CLAT has said it's option B. Monogamy as a law was abolished after 1955. No, monogamy is right now also practiced. One husband, one wife, not more than that. Okay. Question number 9. Does not relate to divorce. Which of the following does not relate to the remedy? And the correct answer is okay. And the correct answer is option B. The introduction of this ground of divorce is unnecessarily as disturbs the sanctity of matrimonial relationships. Option B is the wrong answer. That is the right answer. Does not relate to the remedy. Question number 10. P and Q are married. They are all Hindu. The husband converts into Islam and marries N. Yes. Decide whether Miss Q has a remedy to file a complaint for the offense of bigamy against Mr. P. Okay, the correct answer is D. Yes, Miss Q has a right as a remedy of filing a complaint of the offense of bigamy. Yes, option D is the right answer. Option D is the right answer. So I hope that you are understanding how to solve these questions, guys. It is not difficult. Once you read the passage, the questions that follow are not difficult for you to solve. So definitely do like today's session. Do press the like button. Share this session with your friends. And do subscribe to our beautiful channel. BYJU'S Exam Prep brings to you a booster course on legal affairs and current events for CLAT 2022 Batch 2. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Do share this session and watch this session again and again for your better understanding. Thank you. Bye-bye. Take care. See you soon.